Public servant / policy enforcer questionnaire genesis. Bigger text, plus, smaller text. Whatever the form in which the government functions, anyone entering into an arrangement with the government takes a risk of having accurately ascertained that he who purports to act for the government stays within the bounds of his authority, even though the agent himself may be unaware of the limitations upon his authority. See Utah Power and Light Co. v. United States, 243 U.S. 389, 409, United States v. Stewart, 311 U.S. 60, 70, 108, and C. Generally, in re Floyd acceptances, 7 Wall. 666 Federal Crop Insurance v. Merrill, 332 U.S. 380, 1947. Public officers are merely the agents of the public, whose powers and authority are defined and limited by law. Any act without the scope of the authority so defined does not bind the principal, and all persons dealing with such agents are charged with knowledge of the extent of their authority. Continental Casualty Co. v. United States, 113 F.2d 284, 286, 5th Sir 1940. It is not the function of our government to keep the citizen from falling into error, it is the function of the citizen to keep the government from falling into error. American Communications Association v. Doubts, 339 U.S. 382, 442, 1950. Jurisdiction, once challenged, cannot be assumed and must be decided. Maine v. Thibodeaux, 100 SCT 250. An unconstitutional act is not law, it confers no rights, it imposes no duties, affords no protection, it creates no office, it is in legal contemplation, as inoperative as though it had never been passed. See Norton v. Shelby County, 118 U.S. 425, quoting from Marbury v. Madison, 1803, Marbury holds that a void act is void ab initio. The Constitution requires the judiciary to refrain from enforcing laws enacted contrary to the Constitution. The state citizen is immune from any and all government attacks and procedure, absent contracts. See Dred Scott v. Sanford, 60 U.S., 19 How. 393. Or as the Supreme Court has stated clearly, every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Cruden v. Neal, 2 NC 338 2 SE 70. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no such duty to submit his books and papers for an examination to the state, since he receives nothing therefrom, beyond the protection of his life and property. His rights are such as existed by the law of the land, common law long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution. Among his rights are a refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights, as per Hale v. Henkel, 201 U.S. 43 at 47. McNally v. U.S., 483 U.S. 350, 371 to 372, 1987, quoting U.S. v. Halser, 816 F.2d 304, 307, fraud in its elementary common law sense of deceit, and this is one of the meanings that fraud bears in the statute. See United States v. Dial, 757 F.2d 163, 168, 7th Sir 1985, includes the deliberate concealment of material information in a setting of fiduciary obligation. A public official is a fiduciary toward the public, including, in the case of a judge, the litigants who appear before him, and if he deliberately conceals material information from them, he is guilty of fraud. The law creates a presumption, where the burden is on a party to prove a material fact peculiarly within his knowledge and he fails without excuse to testify, that his testimony, if introduced, would be adverse to his interests. Citing Meyer v. CIR, 199 F2d 392, 396, 8th Sir 1952, quoting 20 A.M. Juror, Evidence, Sector 190, page 193. Notification of legal responsibility is the first essential of due process of law. See also, U.S. v. Tweel, 550 F.2d.297. Silence can only be equated with fraud where there is a legal or moral duty to speak or when an inquiry left unanswered would be intentionally misleading. Sovereign immunity does not apply where, as here, government is a lawbreaker or jurisdiction is the issue. Arthur v. Fry, 300 F.Sub. 622. Knowing failure to disclose material information necessary to prevent statement from being misleading, or making representation despite knowledge that it has no reasonable basis in fact, are actionable as fraud under law. Rubenstein v. Collins, 20 F.3d 160, 1990. A party in interest may become liable for fraud by mere silent acquiescence and partaking of benefits of fraud. Bransom v. Standard Hardware Incorporated, 874 S.W.2d 919, 1994. Extolo mello non oritur actio. Out of fraud no action. Fraud never gives a right of action. No court will lend its aid to a man who founds his cause of action upon an immoral or illegal act. As found in Black's Law Dictionary, 5th edition, page 509. Fraud destroys the validity of everything into which it enters. Nudd v. Burroughs, 91 U.S. 426. Fraud vitiates everything. Boyce v. Grundy, 3 Pet 210. Fraud vitiates the most solemn contracts, documents, and even judgments. U.S. v. Throckmorton, 98 U.S. 61. When a citizen challenges the acts of a federal or state official as being illegal, that official cannot just simply avoid liability based upon the fact that he is a public official. In United States v. Lee, 106 U.S. 196, 220, 221, 1S.ct 240, 261, the United States claimed title to Arlington, Lee's estate, via a tax sale some years earlier, held to be void by the court. In so voiding the title of the United States, the court declared, "No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who by accepting office participates in its functions is only the more strongly bound to submit to that supremacy, and to observe the limitations which it imposes upon the exercise of the authority which it gives." Shall it be said, that the courts cannot give remedy when the citizen has been deprived of his property by force, his estate seized and converted to the use of the government without any lawful authority, without any process of law, and without any compensation, because the President has ordered it and his officers are in possession? If such be the law of this country, it sanctions a tyranny which has no existence in the monarchies of Europe, nor in any other government which has a just claim to well-regulated liberty and the protection of personal rights. See Pierce v. United States, the Floyd Acceptances, 7 Wall. 74 U.S. 666, 677. We have no officers in this government from the President down to the most subordinate agent, who does not hold office under the law, with prescribed duties and limited authority. Cunningham v. Macon, 109 U.S. 446, 452, 456, 3S.ct 292, 297. In these cases he is not sued as, or because he is, the officer of the government, but as an individual, and the court is not ousted of jurisdiction because he asserts authority as such officer. To make out his defense he must show that his authority was sufficient in law to protect him. It is no answer for the defendant to say I am an officer of the government and acted under its authority unless he shows the sufficiency of that authority, and Poindexter v. Greenough, 114 U.S. 270, 287, 5S.ct 903, 912. Whereas, officials and even judges have no immunity, see Owen v. City of Independence, 100 SCT 1398, Maine vs. Thibotos, 100 SCT 2502, and Hafer vs. Mello, 502 U.S. 21. Officials and judges are deemed to know the law and sworn to uphold the law. Officials and judges cannot claim to act in good faith in willful deprivation of law. They certainly cannot plead ignorance of the law. Even the citizen cannot plead ignorance of the law. The courts have ruled there is no such thing as ignorance of the law. It is ludicrous for learned officials and judges to plead ignorance of the law. Therefore there is no immunity, judicial or otherwise, in matters of rights secured by the Constitution for the United States of America. See Title 42 U.S.C. Sector 1983. When lawsuits are brought against federal officials, they must be brought against them in their individual capacity, not their official capacity. When federal officials perpetrate constitutional torts, they do so ultra vires, beyond the powers, and lose the shield of immunity. Williamson v. U.S. Department of Agriculture, 815 F.2d 369, ACLU Foundation v. Barr, 952 F.2d 457, 293 U.S. App DC 101, CADC 1991. Personal involvement in deprivation of constitutional rights is prerequisite to award of damages, but defendant may be personally involved in constitutional deprivation by direct participation, failure to remedy wrongs after learning about it, creation of a policy or custom under which unconstitutional practices occur, or gross negligence in managing subordinates who cause violation. Gallegos v. Haggerty, N.D. of New York, 689 F. Sup. 93, 1988. The law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. Hagens v. Lavine, 415 U.S. 533. If you relied on prior decisions of the Supreme Court, you have a perfect defense for willfulness. U.S. v. Bishop, 412 U.S. 346. Public servant ipso facto policy enforcer. Get your S here. Public Servant Questionnaire. When you look around the web, you'll find a public servant questionnaire, but not like this one. I converted it to a single page so you can get a multi-part NCR form made up at FedEx office, Staples, Office Depot, etc. Keep some by the door to your house and in your glove compartment to give to any alleged law enforcement officers who want to ask you questions. Before answering theirs, I can make them answer mine. You'll find supporting law in 5 U.S.C. 552a. By Bob Hurt. The Public Servant Questionnaire. Key points. An American does not have to speak with a government agent unless the citizen has been arrested. Americans have a right to privacy, to be left alone. The Privacy Act of 1974, Public Law 93-579, empowers citizens to require full, written disclosure from a government official who seeks information. You may insist on complete disclosure as a precondition to speaking with any government official. The limits on federal power. Law-abiding citizens are sometimes visited by agents of the federal government for no apparent reason. It is helpful, at the time of these visits, to recall that unless a citizen has been placed under arrest, either because a law enforcement officer has probable cause to believe the citizen has committed a crime or because the officer has in his possession an arrest warrant issued by a judge who believes there is probable cause the citizen has committed a crime, a citizen does not have to entertain the company of government agents. Citizens also have the right, guaranteed by the Fifth Amendment to the United States Constitution, not to testify against themselves. Thus, when the government comes knocking on 1 superscript 1's door, you have the right to simply say, "Please go away." Unless the government officer places you under arrest, there must be probable cause, or an arrest warrant based on probable cause. The officer must obey your wishes. Be helpful. On your terms. Of course, citizens also have a vested interest in assisting the government in its role of crime solver. Most of us understand the need to help the government to apprehend criminals. But it is also helpful, when the government arrives at your place of employment or at your home, to know how to find out why government agents have appeared on your doorstep. A handy little questionnaire that I came across years ago will do the trick. It's superscript 1s called the Public Servant Questionnaire. A version accompanies this article. The PSQ was developed by Lynn Johnston, author of Who's Afraid of the IRS? Libertarian Review Foundation, 1983, ISBN 0-93007-3-03-7. The PSQ is based on the requirements placed upon the government by the Privacy Act of 1974, Public Law 93-579, an amending law to Title V, United States Code, Section 552, and is included as Section 552A. If a citizen chooses to cooperate with government officials who are seeking information, before questioning begins, the citizen should politely inform the government agent or agents that a prerequisite for the citizen's cooperation with the government is the agent superscript 1's cooperation with the citizen. Do it right, the first time. The questions should then be put to each agent, and the citizen should enter the answers onto the questionnaire. Copies should be provided to each agent, either at the time of the questioning or by mail to the agent after the visit. The questionnaire informs the government agent that the citizen knows his rights and knows which limited powers the government agent has been granted by the people. Most probably some government agents will not want to fill out or sign the PSQ. That's fine. They can then be sent on their merry way. They may need to explain to their superiors, and a court of law, and a jury, on another day, why they refused to cooperate with the reasonable questions of the highest office holder in the land, a citizen. 5 U.S.C. 552A, E3, authorizes a sovereign natural person, citizen, to use this form to collect information from the public servant to determine whether to divulge information to the public servant and employing agency. Public Law 93-579 states, the purpose of this act is to provide certain safeguards for an individual against invasion of personal privacy requiring federal agencies, to permit an individual to determine what records pertaining to him are collected, maintained, used or disseminated by such agencies. Public Servants Questionnaire, refer to Privacy Act of 1974. Public Servant Full Name ID #refused. Driver License #refused. Badge #refused. Residence Address Street City State Zip. Office Mail Address Street City State Zip. Employing Agency or Department Supervisor's Name. 1. Will public servant uphold the Constitution of the United States of America, required by USA and state constitution and law? Yes, no. 2. Will public servant furnish a copy of the law or regulation which authorizes this investigation? 5 U.S.C. 552A, E3A. Yes, no. 3. Will public servant read aloud that portion of the law authorizing the questions public servant will ask? 5 U.S.C. 552A, E3A. Yes, no. 4. What prerogative does citizen have in giving answers to public servant questions? 5 U.S.C. 552A, E3A. Voluntary mandatory. 5. What basis exists for asking the intended questions? 5 U.S.C. 552A, D5, E1. Specific law or regulation used as a discovery process. 6. What nature does this investigation have? 5 U.S.C. 552A, E3A. General, multiple people involved. Special, one person involved. 7. Does public servant reasonably anticipate that any information sought or collected in this investigation will form the basis of or lead to criminal action against citizen or any other entity? Yes, no. 8. Will public servant guarantee only the department employing public servant will use the information or derivative thereof supplied by citizen in this investigation? 5 U.S.C. 552A, E10. Yes, no. 9. Name all files of records, information, or correspondence related to citizen that agency maintains. PL 93 to 579, B. 1. I none. 10. Give the full name of the person in government requesting that public servant conduct this investigation. PL 93 to 579, B. 1. I know 1. 11. Name and identify all third parties public servant consulted, questioned, interviewed, or received information from any third party relative to this investigation. 5 U.S.C. 552A, E, 2, D, 5. I none. 12. Name all other agencies or government sources that supplied any information pertaining to citizen. PL 93 to 579, B, 1. I none. 13. May citizen have a copy of all information pertaining to citizen that other agencies or government sources supplied. 5 U.S.C. 552A, D, 1. Yes, no. If no, state authority for withholding info. I know authority. 14. What other uses may be made of this information? 5 U.S.C. 552A, E, 3, B, E, 3, C. I none. 15. What other agencies may have access to this information? 5 U.S.C. 552A, E, 3, B, E, 3, C. I none. 16. What will be the effect upon citizen if citizen should choose not to answer any part of these questions? 5 U.S.C. 552A, E, 3, D. I none. Public servant affirmation. I swear or affirm under penalty of perjury that I have answered the foregoing questions correctly and completely in every particular. I wet ink signature of public servant date. Citizens witnessing name and signature administered oath date witness name and signature date note. Citizen may administer oath to public servant if no one else exists to witness public servant affirmation.